often. I'll get Sian to introduce herself in a minute, but just a little bit of housekeeping before we get going. We've got a chat panel on the right-hand side. Please use that to chat to each other, to exchange any tips and ideas, and my colleagues will be busy in the chat posting links to any resources that might be useful. We do have live captions on today's webinar. There's a green button underneath the screen. If you click that, the webinar will open in a new window with the captions. If you do that though, please close this original window, otherwise you'll get an echo. We will try to answer as many questions as we can throughout the webinar. We've already had quite a few posted already, but if you have any other questions for Sian, please post them underneath us in the Ask a Question panel. There's a little pop-up box there, and if you miss anything, don't worry, because we are recording the webinar and we'll make the recording available on our YouTube channel later today or tomorrow morning. So first of all, Sian, can you introduce yourself please, and maybe give us a little bit of an outline on what the relevant law is surrounding redundancies?
Hi, thanks Anna, thanks for inviting me again, and hi to everybody, thanks for joining. My name is Sian Clarke. I'm one of the employment lawyers at Slater and Gordon, and we're a claimant-based firm, and so my work is all predominantly with a number of unions, and obviously at the moment redundancy and settlement exercises, settlement agreements is taking up sort of a lot of our work. It does seem to be very prevalent at the moment. In relation to a redundancy, obviously there are different types of scenarios, but with a redundancy, there are certain sort of criteria that a company will have to follow if there are a certain number of people being made redundant. And obviously that's what you're seeing at the moment when you hear stories in the media about certain companies who are making a certain number of redundancies. It's because they've had to notify and sort of publicise the fact that redundancies are taking place. So there is a consultation period that's supposed to take place during a redundancy process, and that consultation process is so that the employee can have discussions about various ways to try and maybe minimise the number of redundancies, look at different measures that can be taken. There are some situations when that doesn't happen. A company goes into administration very quickly overnight, and obviously in those circumstances it's going to be impossible to have consultation, but there are statutory provisions in place that people can have an award from the employment tribunal because there hasn't been any consultation in those situations. And obviously if you've got reps, trade union reps in place in situations like those, then obviously the reps will be making sure that employees know what actions can be taken on their behalf. So there, depending on the sort of different type of scenario, the different type of workplace, the different types of numbers involved, there are sort of various processes, but hopefully there will always be a structured process which reps can engage with, but we know obviously that doesn't always happen.
Thanks, Sian. That's a great intro, and we obviously know that most of our audience are workplace representatives, so they have a very particular role in this process, as we know, and I think because we have reps in a huge variety of workplaces, that's perhaps why we get such a wide variety of questions as well. So I'm going to try and, like I said, we'll try and answer as many of the questions as we can. So first of all, Sian, can you talk a little bit, please, about what the rights are of women who may be on maternity leave, who might be facing redundancy? What can they expect, and what can a rep do in this situation?
Well, the first sort of thing to consider is that despite the person being on maternity leave, their rights to be engaged in a consultation process, to a redundancy payment, to proper notice provisions, that does not change at all. And if an employee felt in any way that they were being treated differently, being treated less favourably, then there could potentially be a claim for discrimination. I know that if you put the sort of COVID situation and mass redundancies aside, it's quite a common scenario, somebody being off on maternity leave and all of a sudden a company or an employer wanting to undergo a restructure, and it so happens that that person who is on maternity leave might be, their job is at risk. And in those circumstances, that's where the rep may be sort of alerted to the fact that this sort of really is a discrimination type of situation, and the person who's off on maternity leave is being made redundant purely because of that. I know that's very difficult to prove, but that's something that unfortunately does happen. Obviously, in this sort of pandemic scenario where we know that there are redundancies across the board, and it may not be the case that there is somebody being specifically targeted for a redundancy because they've taken maternity leave. In those circumstances, the person who is off on maternity leave, as I say, should have exactly the same process, should be entitled to consultation meetings, the same notice as anybody. There shouldn't be any difference in treatment. It may not be if you've got people who are in the workplace now, and it might not be feasible for somebody who's off on maternity leave to actually come in and attend consultation meetings, but obviously they should be still arranged, and there should be facilities in place for those meetings to be taken remotely. And as I say, it shouldn't impact at all, either sort of financially on that person or in respect of the whole sort of redundancy consultation process.
Thanks, Sian. I think some useful advice there for workplace reps who may have members in this situation, and to remember that there are a multitude of ways that you can make provision for these people to be included. I think we've all got used to speaking via screens, so maybe that's just one consideration there. Okay, so we've talked about pregnancy and maternity discrimination, but obviously there are equalities issues that are broader than that. Can you talk a little bit, please, about how to possibly identify other discrimination, for example, disability discrimination, in a redundancy exercise?
Well, one of the things that comes to mind straight away, obviously in a redundancy exercise where a company may be getting rid of, say you've got a company that has 500 employees and they are looking to reduce the workforce, the sort of head count, and they want to, reduce it by 100. So they're looking for 100 people to be made redundant. Now, normally companies will take a first step of approaching the workforce and sort of saying, well, is anybody interested in taking voluntary redundancy? And so you could have a situation, obviously, with age discrimination, a company might approach people that they think are nearing retirement anyway, encouraging them to consider sort of early retirement. And that potentially could be an age discrimination issue. If there comes a point where there are not enough people taking voluntary redundancy and the company has to take sort of a mandatory redundancy scenario, and so people are going to have to lose their jobs even though they're not volunteering to do so, in those circumstances you might have a selection process put in place so that the company can look to see what steps they can take to make sure that the company is going to sort of progress and retain the most useful people to the business. And in those circumstances, obviously, what would give a rep cause for concern is if a person's attendance or ill health or anything surrounding that nature was used as a criteria in the selection process, because obviously that person who potentially does have a disability, who perhaps has taken time off work because of disability related reasons, is going to be subjected to a detriment, maybe because of the selection process and how it's working. So that's something to be mindful of if you get to that stage.
Thanks, Sian. And while we're talking about selection processes, you talked a bit there about equalities and potential discrimination. But can an employer select someone for redundancy if they refuse to change part of their working pattern? So, for example, changing what shift they work or perhaps their hours.
Well, this is sort of a difficult one, really, because you might have a situation in a company where, to be fair to the employer, they are doing their utmost to try and ensure that there is a minimum number of redundancies. And one of the things they might look to do is say, okay, well, at the moment, everybody works 37 and a half hours a week, everybody works 5 days a week, everybody has this particular pattern. And what the company might say is, well, we just cannot sustain this many people doing this for this period of time. And so if we were to reduce hours or have a shorter working week, then we may be able to avoid any mandatory redundancies. If you have a situation where somebody doesn't want to take the sort of reduction in hours or change in shift, then obviously a difficulty does arise. Employees will normally have, if they've got written contract terms and conditions, there will be a flexibility clause normally within their agreement, and sometimes you might have a situation where somebody who works in a particular location might be told, well, we can't keep you in this location anymore, you're going to have to be made redundant if you continue to work here, but if you move to another location, we can still keep you. And so a company will, the reps can obviously try and work with the employer and with the employee to see, first of all, what steps can be taken to avoid a redundancy in the first place. But if you have sort of a situation where it's just going to be impossible for that person to make changes, you might have your working hours set up around childcare arrangements or caring for relatives, that type of thing. It might just be really impossible for you to sort of make those changes. Then it might ultimately be that the only sort of outcome is a redundancy. But again, in those circumstances, reps can be quite instrumental and try and negotiate and discuss with the company, first of all, ways to avoid it. And if it becomes that there is no sort of other way forward, it's going to have to be redundancy, then maybe that person could be entitled to an enhanced redundancy payment as opposed to just the sort of statutory redundancy payment. So it's difficult to give a definite yes or no answer. It obviously depends on the circumstances and depends on the employer.
Sure, thank you, Sian. And I think we, if any of you watching have done the TUC reps training, we always encourage reps to often use the statutory guidance as a minimum, and often there'll be a contractual extra or a negotiated extra. So we've got lots of resources and training that could help you with that. Hopefully a link will appear in the chat shortly. Okay, so we've had quite a few questions about the status of annual leave. So can you talk a little bit about that, please, Sian? So how annual leave works with, or how it would work in a redundancy situation. So can an employer force you to use it all up, or can you add it to a payment, for example? What's the situation around that, please?
Well, obviously, the situation with the annual leave, we know that employers will be doing their utmost to try and sort of reduce their liabilities. And so if you have a situation where you are making 50 people redundant, and they're obviously going to be having a redundancy payment, the employer then might think to themselves, well, hang on a minute, all of these people have got 2 weeks leave left, we're going to have to pay that as well. And so might encourage people to take leave. Obviously, it depends on the circumstances. You have a situation at the moment where many of your reps engaged in the webinar this afternoon might still have their members out on furlough. And I know that obviously employers have a duty to make contact with their furloughed workers every so often. And I know that you've had a situation since March. Obviously, employers will be saying, encouraging people to take leave. And because it may well be that whilst they're on furlough at the moment, when the furlough scheme ends, their job may be a bit more precarious. Redundancies may be sort of down the pipeline. And so in that case, the employer will be looking to sort of reduce their liability. If you've got a situation where somebody hasn't taken any leave at all, within a sort of prescribed period, then obviously the employer has got a stronger argument to say that they're only looking after somebody's welfare, mental health, their well-being, in order that they take leave. It's important that we all use our leave, but obviously, cynically, you will quite often be in a situation where an employer is saying, no, this leave is sort of you have to take leave. Now, I suppose it will depend on what the usual provisions will have been. At the moment, we are in what is typically called, I don't know whether it's still sort of called this across the board, but I've always known it as sort of minus fortnight, where you have a lot of companies will have a 2-week shutdown. And so in circumstances like that, people's leave is quite prescribed through the year. They have to take their leave at certain times. But if you work in an organisation that doesn't have that, then obviously if you've got somebody who is on, at risk of redundancy, or you think that redundancy is coming down the line, then obviously I would be looking at what the leave provisions are, what the normal sort of requests are, because if somebody normally has to go through quite a process to ask for leave, and depending on leave being granted, if you're now in a situation where you're being told, oh, you can take leave tomorrow, please, it is, obviously the company is only enforcing that to try and reduce their liability. And so again, I would look at sort of what the procedures are, and I would make sure that, the company is not acting or not, going above and beyond what their normal processes and procedures are.
Thanks, Sian. We've also had a whole batch of questions about pension rights and redundancies. So what are the rules and guidance, best practice for reps about what happens to pensions if somebody is made compulsorily redundant? I appreciate that financial advice is quite a massive area and very deep. So just the kind of general guidance for reps would be really helpful.
Yeah, as I wouldn't be regulated, and I definitely wouldn't even try to give any sort of pensions advice. Normally, when you're doing cases and you have to try and work out somebody's schedule of loss and its pension rights, it's straight away, oh my God, you have a sort of a mental block. But in relation to the redundancy process, again, it's, and I feel that sort of, hopefully I'm not repeating myself too much, but it depends on the type of organisation. And if you are in an organisation that has had, a company pension or an occupational pension, then the likelihood is during the redundancy process, the company will be looking to obtain figures for people so that people can make an informed decision as to whether or not to accept a voluntary redundancy, so that figures are obtained. And somebody knows exactly what sort of, what their pension is, what their projected figures are, etc. Now, if you've got somebody who is sort of working in local authority and, you've been working for about 10 years, but you might be being made redundant, you're only 35, and obviously what's going to happen is that pension that you've paid, that's being paid into until that point, is just going to be frozen. You're not going to be able to access it or do anything until retirement age. You may be working in another type of organisation which will put provisions in place for, redundancy situation where people will be able to access their pension at a sooner date. And this normally will all be sort of, it will all become sort of evident when the reps are engaged in the process. I know from sort of my own experience at the moment in the cases that we are dealing with, we have different types of scenarios where obviously the pension and the age at which point somebody can access their pension is quite sort of a crucial thing, and sometimes a bit of an enticement for somebody to accept terms that are being given to them. So in terms of sort of the reps sort of position, obviously the first thing to do is to make sure that there is provision in place that if there's a possible voluntary redundancy situation, that the company is obtaining pension details for prospective candidates for voluntary redundancy, so that people can make informed decisions, and just sort of trying to gain as much information as possible from the employer as the process goes forward. If somebody feels that they are being treated, if there's some discrimination issue, if somebody feels that somebody in a certain age category is able to sort of access their or is being treated any differently, then obviously it could give rise to an age discrimination case. And I would say to the reps to maybe explore that in more depth and maybe sort of refer it to their legal team.
Thanks, Sian. That's great. And especially the bit about, if you're referring things to the legal team, always, if you're not sure as a rep, consult your union, especially around things like financial questions, which, as we said, are complex and wide-ranging. So, Sian, we've got a few questions about the redundancy process itself. Can you talk a little bit, first of all, about what the timescale is with redundancies and what the timescale for the process is? And then perhaps what would be your key ways to illustrate that a process has not been meaningful and has not been carried out in the way it should be?
Yeah, thanks, Anna. First of all, obviously, in relation to the timings, it depends on the numbers you've got. If you are, a very small company, you've only got, a handful of employees, then there's no sort of specific stipulation in relation to timings. However, if you're a company who is making between 20 to 99 redundancies potentially, then there is a 30-day process. If there are 100 or more proposed redundancies, then there is a sort of 45-day process. And so there are sort of statutory regulations a company will have to follow. Coincidentally, I'm actually running a case at the Employment Tribunal at the moment in respect of a protected award. And the fact that even though on paper, on the face of it, the company has ticked the box and said, yes, we've done all this, amazing consultation, but in reality, it hasn't. And so I suppose as reps, something that you're, I'm sure very alive to is that the consultation has to actually be sort of a two-way process, first of all. It's not simply a case where, employees are told, well, this is the consultation, there's a Zoom presentation where some slides are put up and, no questions, no follow-up, anything like that. I would say that's not really meaningful consultation. Meaningful consultation is where there is sort of a dialogue between reps, the nominated workplace reps, and the employer about ways that dismissals can be avoided, about trying to reduce the number of employees to be dismissed and to mitigate the consequences of dismissal. And you can't have those discussions, meaningful discussions, if you've just got the employer sort of on a one-way street giving a presentation and that's it. There has to be an opportunity for representations to be made, for those representations to be taken back, and then for reps to be shown what consideration was given to these representations, and if they're not going to be acted upon, then why, what are the reasons for that. And so really I would say that hopefully, because by the time it gets to us, to legal, obviously whatever's happened is broken, and that's why it's with us, and that's why we're trying to rectify things, and we're in litigation. So whilst we hope that situations don't get to that, reps should be mindful that it can. And so what I would say is it's obviously key, making sure that you've got emails, audit trails, everything that you've sent to the company, suggestions that you've made, figures that you've put together, proposals, etc., and responses back, minutes taken from meetings and things like that, so that if it comes to a situation where you feel that there is scope for a claim, such as you mentioned, Anna, the fact that there hasn't been meaningful consultation, then in those circumstances, obviously paperwork, evidence, things like that would be key to present at the employment tribunal stage. Obviously, because there may be sort of a belief that you can only bring a claim for a protected award where there's been no consultation in a circumstance, in a situation where the company has gone bankrupt. There's anybody, in a mass redundancy situation, if there hasn't been a consultation process that's meaningful, that protection is still there, and members would be entitled to bring claims to the employment tribunal.
Thanks, Sian. And there's lots more information and sort of checklist guidance for reps in some of the training that we offer through the TUC. So do check that out if you want like a quick checklist to refer to of covering a lot of the things that Sian has said. Okay. Can we talk a little bit now, Sian, please, about redeployment and selection for redeployment, what suitable alternative employment guidelines might be, and, for example, what someone's rights might be if they turn down a redeployment opportunity or suitable alternative?
Yeah, again, varying circumstances, because you may have, we've all dealt with cases where you have a situation, say for example, somebody works in local authority and they have these sort of redeployment registers at any one time. You may have one of your members who is in the mobile caretaking team, and then when they're given the redeployment register, the jobs on there are, for an accountant, for a teaching assistant in a school, and that type of thing. And it's just, ridiculous. And the redeployment is just not going to work at all. So it all depends, I suppose, on, the individual involved, and what steps are being taken by the company. Is it genuine, legitimate? Do they really want this person to be redeployed? In some circumstances, then it may well be that there just is no scope for redeployment, and in those circumstances, or what's being offered is just not suitable alternative employment, and that may be a genuine case. And in those circumstances, if the employee ends up being made redundant, then it's unlikely there's going to be any grounds or merit in bringing an unfair dismissal claim. However, I would say that the redundancy cases that we do that end up at the tribunal stage, a significant number of those cases are surrounding arguments where what was perceived by the employer to be suitable alternative employment is not by the employee, and obviously then, you know, taken on by us as merit to a case. And so it's, you know, always worth sort of exploring whether or not it's not really genuine, and being mindful that if the employee doesn't take the suitable alternative employment, that if somebody is then considering a possible unfair dismissal claim, the chances are they've already had their redundancy payment, and so you would only be seeking, you know, a compensatory award if the matter went ahead to the employment tribunal. And obviously always being mindful that in the employment tribunal, time limits are really, really short, and somebody only has 3 months from the date that the dismissal took place to bring a claim, and obviously the ACAS process has to be gone through already. So if you are in that situation with any of your members, then you know, and you've explored it and you think that there is sort of scope here for a claim, it's not really genuinely suitable alternative employment, then, you know, I would be saying refer it to your legal team, and you know, be exploring quite quickly whether or not there's merit for a claim.
Thanks, Sian. Yeah, I think the key takeaway from that is make sure you've got records of everything as well, and obviously the because the time factor is so key with bringing a claim to a tribunal, don't delay. So can we talk a little bit next, please, about payments? So just maybe the general outlines about redundancy payments, statutory and possible contractual ones, but also we've had a question regarding bonus redundancy payments and what might happen if a employer refuses to pay a bonus that somebody is entitled to. Would there be any legal recourse there?
Yeah, well, obviously, thanks for that, Anna. And sort of 2 stages to this, really. Obviously, we know that there is qualifying criteria for redundancy payment. Somebody has to be employed for a period of 2 years before they're eligible. But if somebody is eligible for a redundancy payment, there is the sort of statutory redundancy pay, which is calculated using a formula I'm sure you're all very well acquainted with. It's you know, your age factor times how many years service you've got times a gross weekly wage, which is currently capped at £538. And there are, you know, countless tools available on the internet, but direct.gov obviously is the one that we would go to and rely on. But there's, you know, resources there you have through TUC in order to be able to calculate somebody's statutory redundancy. Quite often companies will have contractual redundancy pay, and in situations where you have mass sort of redundancies, and where companies are trying to encourage people to come forward, perhaps in the first instance take voluntary, you will have these contractual redundancy payments, and you know, there will be enhanced sums. In relation, you know, I can't give you any financial advice, but just and I'm sure you're all aware of this, in relation to a redundancy payment, it would be the first £30,000, which is tax-free. If you're receiving a redundancy payment that's over and above that, that sum is going to be taxed at your ordinary taxable rate. In respect to the bonus question, there is case law that suggests that if you have somebody who has a particular wage, then really the redundancy should always be paid, you know, it should be calculated in accordance with their ordinary wage. Because you sometimes have situations where in order to try and save their job, a person has agreed to go part-time, or a person has reduced their hours or anything like that. And the case law suggests that in those circumstances, if you end up in a redundancy situation, it really should be your sort of, you know, original, your proper income that should be used as the calculation. And so in respect of this bonus point, then obviously if the employee can demonstrate that really the bonus is an integral part of your wages. Now, quite often you get, in fact, I've been doing some work on a case today where somebody's basic pay is quite sort of, it's at a level, but really their annual salary for the past sort of 13 years has been at this level because there is a bonus and it is always paid. And so in those circumstances, if it's contractual, I would say that there is an argument to say that the bonus, it is part of that person's wages and should be used within the calculations. If it wasn't, that person could potentially have a claim of unlawful deduction of wages, or some other recourse against the company. Again, I'd make sure that your member is mindful of time limits, and for an unlawful deduction of wages, we know that it's 3 months from the date that the last deduction was made. So it's always worth trying to scope out everything that you potentially could be entitled to.
That's great advice, Sian. Thank you. Can you perhaps offer some advice, please, about what reps should do if there are two different groups within the same organisation or the same department who are being treated differently in this situation? So the example given is that we've got two groups being offered different enhanced terms for voluntary redundancy at the same time and for the same reasons.
Well, obviously it's difficult without knowing the exact background. It could give rise to a claim of discrimination for the one set, for the one group, if the difference in treatment can be attributable somehow to a protected characteristic. I would imagine that the company wouldn't open themselves up in terms of a mass discrimination claim. So whether or not it would be difficult to obtain evidence, or difficult to show a tribunal that yes, this is the difference in treatment. But if a rep in those circumstances is having members come to them to say, well, hang on a minute, why is that department having this? And it's definitely worth exploring whether or not there is some kind of action that can be taken, and whether or not the matter should be referred to legal. I feel like I'm sort of like batting it off all the time, saying, yeah, just sort of refer it to legal. But obviously it's difficult without knowing the exact circumstances, but I'm sure, reps are alive to sort of, potential issues, discrimination issues, and that if a group feel that they're being treated any less favourably, or what the company are doing is somehow going to put them at a detriment as opposed to another group, then obviously it's worth exploring. Could be a perfectly plausible reason. The company could be doing it on a length of service, or on job, your grades, things like that. So the company might be able to defend any potential discrimination claim, but it's worth exploring in the first instance.
Thanks, Sian, and sorry for just putting you immediately on the spot there. It's
oh, no worries.
Okay, I think we've probably got time for a couple more questions. We've been asked if how can reps challenge employers who use a restructuring process to make everyone redundant and then reapply for very similar jobs? Is there anything a rep can do in that situation? And have you got any advice for them if they're faced with that?
I suppose in those sort of circumstances, where you have sort of a restructure, obviously, if you've got a restructure based on voluntary redundancies, is it sort of, if there is a restructure, it's usual that some jobs within the organisation are going to be reduced, and so they're going to be reduced either voluntarily or, in a mandatory situation. But it's usual for employees to be able to apply for any new roles. But roles that are going, if they're not normally advertised, if you have a situation where you've got a company saying, right, we're getting rid of these 500 roles, but actually in a very short time, or people can reapply for something that's very, very similar, it might, you might think, well, hang on a minute, this is not a genuine redundancy. A company is always able to look at restructuring, and obviously a company is going to argue, well, we have to do what we can in order to make ourselves economically viable. We want to be able to keep the best people to do the jobs type of scenario. I don't think that they would put it in those terms, but that's potentially what they're saying. But I think that the employer should be consulting with the union as to the sort of desired way that they want to, or to, they should be consulting with the union in relation to what they want to achieve. And the employer should be seeking to agree with the union a criteria that's going to be used in selecting the employees. And so, there is case law that reps can refer to that's really sort of widely known and adopted by the Employment Tribunal. It's the Williams v. Compare Maxim case. So that sort of sets out provisions, and I think I put that when I sent the notes, when obviously we had the webinar back in June, which we had our internet issues.
Yeah, we had a disaster, didn't we, with Virgin Media having no connectivity, and we had to abandon it after about 15 minutes.
Yeah.
But yeah, we do. I'll make sure we dig out a link to that that you sent last time, and we can send it to anyone tuned in today.
Yeah, so I would say, if the reps are sort of the belief that, well, what's happening here is not really a genuine redundancy, and it's a way that the company is trying to get rid of a certain sort of swathe of employees in order to, move forward in a way that the reps think is not, genuine or fair to everybody, then obviously that's something that should be challenged during the consultation process. Sorry about this. One of the sort of perils of this type of scenario.
It happens.
So it's really just sort of making sure that the reps are being out there challenging the process and ensuring that everything is recorded. They're doing their utmost to ensure a fair selection process, and if they believe that there is any sort of underhand, or if there's any hidden agenda in respect of a restructure application process, then challenging that and potentially sort of taking it forward.
Yep, thanks, Sian. Okay, I think we've got one last question, which I think we've got time for, and I think it sort of sums up things quite well. All the advice you've given so far has been really great and useful for reps, but I think it's it has applied to redundancy situations for many years. However, we all know we've had a very, very unusual 4 and a bit months. It's a situation that we've really never had before, and I'm sure we all hope never have again. But do you have any particular advice, things that you've noticed over the past 4 months that are particular to COVID, the unusual situation that we've got with furlough and the job retention scheme, again, something we've never had before, and redundancies? What can reps do at the moment, or what should they be looking out for in this unprecedented situation?
Well, firstly, obviously, yeah, it has been a very, very unusual situation. And I know from our own experience and queries that we are getting from reps and from sort of potentially existing clients, is that if you are put on furlough, then obviously you feel that you are potentially exposed and maybe the first who will go in any eventual redundancy situation. First of all, what I would say is that that can't be used as a criteria. It would be completely unfair, and I would imagine that employers, whilst we're all quite sceptical about the role of HR, etc., but hopefully they will have some genuine advice from their whoever they take advice from, on the basis that that would be opening themselves up to all manner of claims. So hopefully to allay any fears that people have in that situation, all employees would have to be treated on an equal footing. In respect of the COVID-19 situation, obviously we know that here we are doing a webinar. It might well be we get to September time, normally be going along as reps to national conference, that type of thing, and it might well be that we're still in this situation now, and so we've had to adapt. And I know that when this situation first arose, I had quite a lot of concerns from our reps who I deal with directly in various different organisations, that people wouldn't be able to to have disciplinaries on Zoom, to have consultation meetings on Zoom and that type of thing. And so I know that, again, that is a worry. I would hope that by this stage, sort of down the line, people's sort of adaptability, or people have got used to this may be sort of the only way that things can get done. And so I think that it's not so much a case now that companies are trying to get away with doing things properly because they're doing it in this way. And I know that the reps would still be sort of challenging wherever they feel there's not a fair process, but unfortunately, it might well be that we have to accept that some meetings are going to be taking place like this, and there's nothing that we can do sort of to avoid that. But again, reps making sure that you might have people who are not au fait with technology, you might have people who don't really sort of know how it works and that type of thing, and so reps making sure that people just aren't being sort of missed out or missing their opportunities to be putting forward their sort of their case during any consultation process. There, in sort of the redundancy process, obviously there is a defence, that an employer can use, that they were unable to consult, but under sort of legislation, it has to be something that's really exceptional and out of the ordinary. Now, back in March, we might have thought that it was really exceptional and out of the ordinary, that we're all working in this type of environment. But I think at this stage in the pandemic, when things have become a lot more settled, there is easing of lockdown, companies are maybe opening back up, and even if they are not, this type of system is becoming really well adopted. I think that a company would be really, really hard pressed to say that they couldn't consult, and they have a defence to not being able to consult because of something exceptionally out of the ordinary, because unfortunately this is no longer out of the ordinary. It's that phrase that everybody absolutely detests. It's the new normal. And so I think that companies are not going to be able to use that as a defence. So I think that on a practical note, what reps can possibly be looking at is if they are, in a situation where they're being put on notice by their employer that there's going to be a redundancy situation, and it's being blamed on the position that the company is in because of the pandemic, then obviously, obtaining figures relating to that company, obtaining information about, what government help is in place, has the company utilised all the government help is in place, really sort of trying to obtain as much background information as possible, so that when you go into these consultation meetings, when you go into sort of meetings with the employers, you've got, ammunition to be able to say to them why you think that the redundancy is, unfair, or why you think it can be averted in some way.
Thank you so much, Sian. I think that's some incredibly helpful advice there, especially the bit about this is the new normal now, and the defence that previously may have been able to be used in March and early April probably won't wash now, because we're all very used to this. So all that remains for me to say is to thank Sian so much for another fantastic webinar. As she mentioned a minute ago, we did try to do this back in June, but we had some disastrous technology problems, so we're really grateful that she's joined us again today. Thank you everybody for joining. You've been fantastic, and we've had some really, really great questions posted, and we have tried to answer quite a lot of them. There's a very timely comment from a viewer a couple of minutes ago saying it was a great webinar and that we should keep them going. We are going to keep them going, but for those of you who are regular viewers will know we've done a webinar almost every week since mid-March, since COVID-19 has been with us. However, we are going to have a few weeks break. There won't be any webinars during August, and we'll be back in the early autumn, so probably mid-September. No date has been set yet, but do watch this space, and we will be back with more information for you in your role as reps. Maybe we can get Sian back to do another webinar in the future. But have a good month, have a good August, and we will see you again soon. So bye from us here.